We will explore how Danish unions shape labor laws and workplace rights, and why the Danish model has become a reference point for policymakers and business leaders around the world. Denmark is often associated with high wages, strong social protections, and competitive companies, but what is less visible from the outside is the institutional architecture that makes this possible. At the core of that architecture is the relationship between trade unions, employer organizations, and the state. Unlike many countries where labor laws are set primarily through detailed legislation, Denmark relies heavily on what is known as the collective bargaining model. In simple terms, this means that the majority of rules governing pay, working hours, training, job security, and dispute resolution are not dictated by Parliament, but negotiated between unions and employer associations, sector by sector. To understand the role unions play, we need to look at three key features of the Danish model: high union density, strong employer organizations, and a deliberate choice by the state to delegate much of labor market governance to these social partners. Union density in Denmark remains among the highest in Europe, with a large share of employees, especially in the public sector and many private industries, choosing to join unions that are closely aligned with specific sectors or professions. These unions are not only membership clubs, they are core institutions that negotiate collective agreements, represent workers in disputes, and engage in structured dialogue with employers and government. On the employer side, powerful organizations represent companies in manufacturing, services, construction, and other fields, and they act as collective counterparts to the unions. This mutual organization on both sides supports a system where negotiated compromises are the norm rather than the exception. Historically, a landmark moment came with the September Compromise in 1899, when unions and employers agreed that employers have the right to manage and allocate work, while workers have the right to organize and strike. This foundational agreement established the principle that labor relations would primarily be governed through collective agreements, setting the stage for more than a century of structured negotiation rather than constant confrontation. Today, this heritage is visible in the way most workplace rights in Denmark are formed. Instead of Parliament specifying a single minimum wage, sectoral collective agreements define wage floors and pay structures for different occupations and experience levels. Instead of rigid national rules on working hours, agreements outline standard hours, overtime pay, shift premiums, and flexible arrangements that reflect the realities of specific industries. In practice, this means that unions are deeply involved in shaping the lived experience of work, from how performance is rewarded to how redundancies are handled. One of the distinctive features of the Danish model is flexicurity. Employers enjoy relatively high flexibility to hire and dismiss employees compared to many continental European systems. But this flexibility is balanced by strong income security and active labor market policies. Unions are instrumental in maintaining this balance. Through negotiations, they secure severance terms, notice periods, training and upskilling opportunities, and frameworks for redeployment. They also sit at the table with government and employer organizations when national strategies on reskilling, unemployment benefits, and green transition initiatives are designed. In doing so, unions help ensure that workers who lose a job are not simply left behind, but supported in moving into new roles, often in emerging sectors. Another dimension where Danish unions shape workplace rights is through co-determination and employee representation. In larger companies, employees typically elect representatives to cooperation committees and, in some cases, to company boards. These representatives, often union-backed, participate in discussions on working conditions, organizational changes, and strategic initiatives that have implications for staff. Rather than being purely adversarial, these forums are designed to foster constructive dialogue, with both sides incentivized to find solutions that support productivity and employee well-being. The presence of formalized cooperation mechanisms means that significant changes, such as restructuring, digitalization projects, or new work time arrangements, are usually accompanied by structured consultation and negotiated safeguards. Unions also play a critical role in enforcement. Because many rules are rooted in collective agreements rather than statutory law, it is the unions that monitor compliance, file grievances, and, when necessary, initiate industrial action. The prospect of strikes or lockouts exists, but in practice, the system is calibrated to resolve disputes before they escalate. Mediation institutions, often co-designed by unions and employers, help broker settlements. This emphasis on negotiated enforcement reduces the reliance on courts and extensive regulatory inspections, and instead leverages institutional trust and mutual accountability. From a business perspective, cooperating with unions in Denmark can bring clarity and predictability. Collective agreements provide standardized frameworks for pay and conditions across an entire sector, which reduces the transaction costs of individual negotiation and can prevent a race to the bottom on wages and standards. For international companies operating in Denmark, unions often act as partners in designing workable solutions that comply with local expectations while enabling operational flexibility. At the same time, unions are not simply conservative forces. They increasingly engage on forward-looking topics such as sustainability, digital transformation, and diversity and inclusion. By bringing workers' perspectives into these discussions early, they can help organizations anticipate resistance, design better change management, and secure buy-in. That said, the Danish model does face pressures. Globalization, platform work, and the rise of non-unionized sectors challenge the traditional architecture. Some parts of the labor market, including gig work and certain service segments, are harder to organize and less covered by collective agreements. Unions respond by experimenting with new organizing strategies, working with NGOs, and in some cases advocating for targeted legislation to close gaps in protection. The state, for its part, typically intervenes cautiously, aiming to preserve the central role of social partners while addressing areas where market changes undermine the reach of collective bargaining. This ongoing adaptation is crucial to sustaining the relevance of unions in an increasingly digital and fragmented economy. For policymakers and leaders outside Denmark, the key lesson is not to copy the system wholesale, but to understand its underlying logic: high levels of trust, strong and representative organizations on both sides of the labor market, and a shared commitment to negotiated solutions. When these elements are in place, unions can be more than opponents to management. They can be co-architects of labor laws and workplace rights that support both social cohesion and economic competitiveness. For employees, Danish unions offer a clear value proposition: a voice in setting the terms of work, access to legal support and counseling, and a degree of collective power that individuals would struggle to achieve alone. For employers, they provide structured channels for dialogue and a framework within which fair and sustainable employment practices can be developed at scale. As Denmark continues to navigate demographic shifts, technological change, and the green transition, unions will remain central players in shaping not just labor laws and workplace rights, but the broader social contract that underpins the country's economic model. Understanding their role is essential for anyone seeking to engage with the Danish market, benchmark labor practices, or draw insights for reforms in their own national context.